Ready? Yep. Calling case number 2356951, the people of the state of Michigan versus Suzette Bengucci. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, assault with a dangerous weapon, felonious assault. Count 3, assault with a dangerous weapon, felonious assault. Count 4, assault with a dangerous weapon, felonious assault. This matter is here on a hearing. This is son, this exam for tomorrow.
Good morning, Your Honor. Adam Book appearing on behalf of the people, P86266.
Good morning, Judge David Cripps, P34972, appearing on behalf of my client, Suzette Benquish. She's joined us by Zoom.
Ms. McQueen, can you state your name for the record, please?
Suzette Charlotte Bengucci.
Bengucci.
Yes.
Judge, Miss Bengucci and I have consulted about her case. She wishes to waive her preliminary examination.
No objection from the people, Your Honor.
All right, Ms. Bengucci,
Yes.
you understand that it's a statutory right to a preliminary exam where the state must show by probable cause a crime was committed and probable cause you had something to do with committing that crime. You understand that?
Yes.
Anybody promise you anything or threaten you in any way to get you to waive your right to preliminary exam?
No.
You waive your right freely and voluntarily after having opportunity to talk to your attorney about it.
Yes.
And do you have any objection to the court signing your name to the waiver form and initialing all?
No.
And Mr. Cripps, do you have any objection to the court signing your name to the waiver form and initialing all?
No.
Mr. Cripps?
Excuse me?
No, I'm talking to your attorney.
Oh.
Judge.
Yeah. We'll give your attorney a minute to come back on. It seems we lost him.
Here he is.
All right, Mr. Cripps, you back with us? He's frozen again. All right, Mr. Cripps?
Yes, Judge, I can hear you now. I'm sorry.
Okay, that's all right. All right, do you have any objection to the court signing your name to the waiver form and initialing all?
No, Your Honor, I do not.
All right, the court will find that you freely and voluntarily waive your right to preliminary exam and is bound over to Wayne County Circuit Court Criminal Division for arraignment on the information, which will be June 20th, 2023 at 9:00 a.m. Bonds continue. Anything else? All right, Ms. Bertucci, that
Yeah.
concludes the hearing. Thank you. Thank you, Mr. Cripps.
Thank you, Judge. Have a good day.
You too.
Judge, did you want the dockets? No, we don't have the PCCs
Oh,
today.
yeah, let's put it on the board. Tomorrow.
Oh, Mr. Crip. Courtroom 233, Judge Giles, courtroom, you may have to. Hi, Mr. Crip. Oh, it was, June 20th. June 20th, yep, 9 a.m. You're welcome. Oh, no problem. All right. All right. You couldn't hear the ring. Hey, man. Try all weekend, look for the nuts. I didn't find any out, the church had something else in the church. Oh. Cause even these are kind of hard to find, I just got some. Right, right, cause I took a picture of your, trying to look for them, but they're hard to find. These are the big ones. Yeah. Oh, they sure do. Yeah, cause I seen these, I was like, no, that's not the ones he had, but I knew they had cranberry one, right?
So how can I try to keep a big bag if you want?
I was just trying to get, I was just trying to see if they had snack sizes.
Right.
This is like an energy. Yeah, it's not- that shit. Do they have this size like in a book? It's individual.
If they did, it would be too much. If that, that's like.
Oh. You said Rogers, why are you asking about Rogers?
He's a jail rat, so.
He's not on the docket today.
Tuesday, 11:15, but didn't his attorney call from Washington, right?
Is that the one that we adjourned?
Oh, is that what we did?
Does he have 3 cases?
Yeah.
Yeah, we adjourned that one.
Dude, you gotta give me a new docket.
I had to give it to him.
No, we got the same one.
That's the only thing that's good.
We got one. That's good.
Oh, no,
Scratch it out.
that's, yeah. Well, what happened? Yeah, this is an old document. Don't even have the 10 o'clock on here, or the 10:15. You got the same one? I swear.
You might have put it on here.
Yeah, I can just make copy of this.
Oh.
That's the right one there. You put it on.
I put some copies over here. Okay. Got 'em. Oh.
Yeah, you didn't look at it. I said, what?
I gotta come up.
Well, maybe they'll come in.
Oh, no. That's how it happened.
Do it. Does she have?
Yeah, she has.
How you doing, Mark? Hey, Mark, how you doing?
Hi, how you doing?
You all right?
Good. I haven't seen you for a while.
It's been a while, yes.
No,
You see the pieces of the.
something interesting, but it just wasn't.
You left your reward. So. It was good. But it was nice. Okay. Not there. It was not this. No, me and Bart. Goodbye. Smart. Please stay in trouble. Well, I just told you.
You got sharp, sharp.
Yeah.
I got it. Yeah,
You gotta change it to me. Let me look at my schedule too, okay? Wait, what?
It doesn't matter, next week.
Exactly. You get to pick up the schedule. It's gonna be- Exactly.
Meeting.
All this type thing, figure out what's going on, what's trying to do. And you need to know. If you guys are- I can't hear what this. Yeah, it goes right, I don't know. It's off, like, it's off. Compared to a lot of things.
Yeah. This is-
Even if it's not, you got, you don't do one good, you can still. Or sell half of it, still have it. You should have
We got.
2 acres, you got 3 acres.
No, we got 5.
Well, no, if you
Well,
sell
actually,
2.
we got 6.75. One of the families, the guy, Kwame, his wife got the 4. So, money from somebody who wants to sell it.
You trying to turn.
How much you sell?
Mr. Henderson?
Yeah, that's smart.
Tracy.
Okay.
Sister.
What's your name? Oh, okay. I had the pleasure of being in front of him. Oh, he's so nice. He's a no-nonsense judge.
So we took, right now, we have 1.75 acres. Little brook,
On the first case,
Pay for it all.
you know about the case?
The
First case. Is that Alyssa? Yeah. Alyssa, it's a girl.
I'm not sure.
Okay,
Well, I tell you that, it's my money, something happens to me.
that's all right.
The first case there.
I might want
The first case, no web, it's coming in web.
Just because they have something.
Yeah, whatever.
Okay, yeah, her first name, Alyssa.
Yeah, just as the last name.
Yeah, that's what I have. I can find it. That's fine.
I would need more than that.
See, I've only worked like 8 months. Retired from cable. So I know all the civil attorneys.
Yeah, yeah, that's what Rob, we did
Oh, Blueberry case, that's sort of come up. Okay. One less. One less good. You said return, yeah.
Yeah.
22nd.
Of what?
July.
Oh, July, okay, okay. That might work. Yeah, make sure I get all of it. That sounds great. I know.
I think it's,
This is good stuff to talk.
The problem is you got community council, small group.
I did tell some people. I had their convention.
Small group of people that live in year round.
Yeah.
Some
Eight
folks
of them got four hands, 6 of them.
No,
You don't think you ever do something?
you can do something.
No, because people, you'll see it, you see who else is sponsoring.
Oh, yeah, the crowded downstairs.
Yeah.
No wine trades.
I don't know.
Oh, yeah.
All right.
Detroit, big turnout. So did you go to, how are you connected? Website or on your own?
All city services is fine.
Yeah.
So he's not working.
Okay, why don't you Google our website? Go to our website.
What kind of money?
Yes, correct. Look for Judge Williams' name. Click on Detroit Attorney. Mr.
He said, he wrote that book. What are you saying? Bunch of trash, he's done on time.
Okay, and it should, you should see that it lists the judge's name.
It just so we value. They know they see it.
That's correct. That's correct. Click it on, yes.
Did you check agree? Okay, you're not gonna go directly into the courtroom, you have to wait for someone to join you in.
That's what gets me, yeah. Sure.
Hey ma'am, I'm gonna give you the courtroom, I'm gonna give you the phone number to that courtroom, because this is not the courtroom we're trying to get into. I don't know how you got this number, I was just trying to, I'm happy to, but I can't sit on the phone. With you, we have a lot to do there, okay? So I'll give you the phone number, and you can call that courtroom, what you're trying to get into. Hold on. It's 965 2285.
I don't care. So you can talk about, that's the ones you don't get sense of loss. That's what you choose. Oasis. I think that was. I haven't.
Okay, I'm not sure what they're asking. That's not the correct procedure.
See, I tell you.
They're trying to use it to do it before our hearing. These are felony matters, get a warrant for your arrest.
I try. I just want to be.
Yeah, Demont Brady.
Depends on what. I think that's the point. See, you told me. What about you?
Okay, so your court date is scheduled for tomorrow. We have an exam tomorrow. We have 2 cases.
Later.
And it's scheduled for exams tomorrow. Yes. Today is the 5th, Monday, June 5th.
We just had one.
We have June 6th.
We just waiting on that. Okay, at 9 o'clock. That's it right here.
Well, it looks like one is an old case. How many cases do you have? Okay, that has nothing to do, sir. That's not what I'm asking.
Attorney on matters.
It's true.
Go web.
What number, what case number do you?
Yes, we know, secure. That was Mr. Glenn. Mr. Glenn said.
Oh, cool. Yeah, he's always here early.
Okay, so he's also has a case number 190553 5701.
Judge is ready.
Detroit.
Yes, it is. It's a B in university.
Judge, I tell you, Glenn is always.
Oh,
He's always here early.
I don't know, that's all I have scheduled for tomorrow.
That's right there.
Yes.
Oh, yeah, I got two of them.
Okay. We're gonna hold up. So we'll just stand up.
Yes, sir. Yes, yes. you can. See you tomorrow. Make sure you're on time. There's no t-shirts, no sweats. Okay. Oh. That's on web, right? Thank you. Parties ready on Joe Webb?
Yes.
Calling case number 2356748, the people of the state of Michigan versus Joe Webb. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
On behalf of the people, Philip Henderson, P86029.
Good morning, Your Honor. Ellis Flicker with the Neighborhood Defender Service on behalf of Mr. Webb, P86432.
Web, state your name for the record, please.
Go web.
Thank you. All right, you ready to speak?
Yes, Your Honor.
Yes, Your Honor.
Just requested all witnesses here.
Your Honor, my OIC is here in the courtroom, and I do not anticipate she'll testify today.
That is fine. Your Honor.
You don't anticipate that she's
She
not
won't
going to.
testify, Your Honor.
Do you know witness testifying today at trial or anytime in the future must leave the courtroom or be denied that testimony? The exceptions to officer charge, and that includes anyone on Zoom and YouTube. Witness.
Your Honor, the state calls Jawan Anderson.
Civilian witness or?
It's a officer. Jawan Anderson.
Juan.
Come on, let's look. Raise your hand. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right, you can put a door towards you.
Please introduce yourself to the court.
Police Officer Kiwan Anderson,
And where are you employed, sir?
Second Precinct.
And the DPD?
Yes.
And how long have you been employed there?
At the police department,
Yes.
9.5 years.
Yeah. Were you working on May 3rd, 2023.
Yes, sir.
Did something happen on that day that brought you to court here today?
Yes.
Could you tell us how it began?
I was a special attention, while I was on patrol.
Okay, and you said you were on patrol, what were you wearing?
I was wearing a black polo shirt, like polo style shirt, a black vest, a badge display on my outermost garments, Detroit Police marked on the front and back.
Were you walking or driving?
Driving.
And what were you driving?
Black semi-marked car with Detroit Police marked on both sides.
Okay, and while you were patrolling, did anything catch your attention?
Yes.
What was that?
The defendant, back in the yellow shirt, walking eastbound on Grand River, toward Coyle.
In this area that you're talking about, Grand River towards Coyle, is that in the city of Detroit, County of Wayne?
Yes, it is.
Okay, and you referenced the defendant, and you identified him in the yellow shirt. Could you also point where he's at in the courtroom today?
Yeah, he's seated to my left, in the pews over here, right, only person over here.
Your Honor, if the record could reflect that he's identified the defendant in this case. Okay, when you saw the defendant, what did you observe?
So like I said, I was doing a special attention on the businesses. This area is notorious for being businesses around nighttime. So I frequently check the businesses. I illuminated Mr. Webb with my department spotlight on my vehicle.
And when you illuminated Mr. Webb, what did you see, if anything?
Yeah, well, he responded to my presence immediately. He made an excited utterance. I ain't doing nothing.
No, you don't decide that. You made a statement, I'll decide.
What was this statement?
He made a statement, I ain't doing nothing wrong.
Okay, and then what did you do?
I noticed when he said that he was fidgeting with his left side of his waistband,
Okay, and what did you do when you saw that?
I ordered him to stop fidgeting with his waistband. He put his hands up. I asked him, was he armed? He said, yes.
Okay, was he doing anything while he had his arms up?
Yeah, he kept looking down at the same area of his waistband.
Okay, so after that, what did you do?
Asked him, was he a concealed pistol license carrier? He stated no. I recovered a 38 special from his waistband, please.
And what color was that?
Black.
Nothing further at this time. Well, no, I'm sorry, excuse me, I apologize, sir. Were you able to verify whether he had a CPL or not?
Yeah, probably, no, he did not.
Okay, nothing further this time, Your Honor.
Good morning, officer.
Good morning.
You prepared a report in this case,
Yes,
and you reviewed that report prior to submitting it
yes, ma'am.
to ensure it is an accurate representation of the events that occurred that day?
To the best of my ability, yes, ma'am.
And you reviewed that report prior to your testimony today?
Yes.
Did you find any inaccurate representations?
I'm sorry?
Did you find any inaccurate representations in that report?
Not to my knowledge.
Prior to obtaining Mr. Webb's ID, you were not aware as to who he was, correct?
No, ma'am.
And you didn't know whether he had a criminal record
No, ma'am.
or whether he had a concealed pistol license.
No, ma'am.
And had Mr. Webb had a concealed pistol license, he would not have been committing a crime, correct?
No.
You say in your report that you illuminated Mr. Webb with your spotlight, and you testified today he was fidgeting with his waistband,
Yes.
and this is what made you suspicious that he was carrying a firearm?
It was the way he looked at me. It was the way he responded to me.
But at this time, you were still unaware as to whether he had a CPL.
Yes.
Got out of your car to investigate?
I'm sorry?
Did you get out of your car to investigate at this time?
As I got out of the vehicle, yes, ma'am.
And Officer Palmer was your partner that day?
Yes.
He made contact with Mr. Webb prior to you,
Yes.
and he placed Mr. Webb in handcuffs?
I can't remember if he was the one. I believe I was the one that placed in the handcuffs. I'm not 100% sure on that, man.
Okay, but then you approached Mr. Webb at some point,
Yes, we both did. Yes, ma'am.
and you removed the firearm,
Yes, ma'am.
and then you asked Mr. Webb if he had a concealed pistol license?
As I approached him, are you a CP or he said no?
You were wearing a body camera that day,
Yes.
and it was activated?
Yes.
If I were to show you that footage, would you be able to recognize it?
Yes.
Permission to approach, Your Honor?
No,
I may not approach.
you may not approach.
Okay.
You want to show him the body camera, it's gonna go on Zoom, that's the way we do it.
Okay. That's fine.
But you're gonna give me an offer of proof of what am I gonna see on his body cameras is different than what this officer testified to.
Yes, Your Honor.
Otherwise, I don't need to see it.
Okay, I can do that, Your Honor. The offer of proof, Your Honor, is in this footage. Officer Palmer first put Mr. Webb in handcuffs, and then Officer Anderson removed the firearm, and before asking Mr. Webb if he had a CPL. So at the time that they seized, Mr. Webb and searched him, they were not aware as to whether he was committing a crime, and they were not aware as to whether he had a CPL at that time.
What difference does that make? They're still investigating.
That is correct, Your Honor, but they have to have reasonable suspicion. I
You
can
have
make
to
this
have
argument.
reasonable suspicion to investigate. They don't, so you haven't told me anything so far.
Understood, Your Honor. No further questions.
All right, anything further?
Nothing further from this witness, Your Honor.
Thank you. Step down.
Thank you.
And the state has no further witnesses.
Yes.
No further witnesses, Your Honor.
All right.
Your Honor. Your Honor, the people would motion for a bind over. In this case, the officer saw someone late at night, high crime area. He illuminated, or an area that they had reports of potential crime. He spotlighted him. He was fidgeting, looking in his waistband, even after he put his hands up. The officers asked him if he was armed. He said yes. They approached him and recovered a firearm and determined he wasn't a CPL holder. Happened in Detroit is the defendant they've identified, so it meets the state's burden.
Your Honor, we would object to the bind over on the grounds of a Fourth Amendment violation. The timeline of the events of this case are imperative. As I described in the body cam footage, Officer Palmer seized Mr. Webb by placing him in handcuffs prior to asserting whether Mr. Webb had a CPL license. While the officer testified that he observed Mr. Webb adjusting his waistband, that is not enough based on the particular suspicion needed established in Terry. Further, the officer testified that prior to Mr. Webb providing his ID, he did not have knowledge as to who he was, whether he had a criminal record, or whether he had a CPL. Yet, Officer Palmer seized him without reasonable suspicion as to whether Mr. Webb was carrying illegally. The officer even testified that had Mr. Webb had a CPL, he would not.
That part is not on the record.
Understood, Your Honor. I'm just
Okay.
making my argument.
But you can't argue it if it's not on the record.
Your Honor, he did state that
He
he
said
had a
he
CPL.
had, no, I'm talking about the part about Officer Palmer. Officer Palmer, what we have on the record is Officer Palmer made contact with the defendant prior to Officer Anderson. Officer Anderson said he put the cuffs on, not Officer Palmer.
Well, Your Honor, he did state that he was not aware as to whether he remembered if he had put him in
So you
handcuffs.
can't
prior,
argue
or-
that Palmer did it because you don't have that on the record.
But I put an offer of proof with
It
the,
doesn't matter. I asked you for offer of proof to tell me what you were gonna show me. And I told you how you had to show it to me.
I was going to show it to the officer, Your Honor, so that he
No,
felt that.
that's not how it works. You put it on the screen, let him see it, he authenticates it there.
Okay.
Period.
Okay.
And then you go to the part you want him to see, or you want to try to impeach him with, or whatever. But you can't, if you don't do it, you can't argue it.
That's fair, Your Honor. All I would like to say, Your Honor, is that seizing a person before having reasonable suspicion that a gun is being carried illegally, as quoted in a report from the Third Circuit, it's like pulling over everyone who drives to see if they have a license. In other words, Your
I
Honor.
don't care about a report from Third Circuit.
It's an order from the circuit. I
Excuse me.
understand it's not
Excuse
binding to
me.
this court.
Excuse me, it's not binding, you're right, if it's not binding, I don't need to know about it. What do I care? That's like saying, John Blow down the street says A, B, and C, am I supposed to take that into consideration? No,
It's just persuasive, Your Honor. and
it's
that's why
not
I would like to
persuasive
argue it.
either.
Okay, Your Honor.
What does a report mean to me from the Third Circuit?
Understood. That is it, Your Honor.
Anything else?
No, Your Honor.
All right, of the hearing, argument and testimony finds that on May 3rd, 2023, in the area of Grand River and Coil City, Detroit, that Officer Anderson was on special patrol, in a modified uniform, semi-marked car, saw the defendant walking, he illuminated the defendant, then turned around, told him I didn't do nothing wrong. He then began fidgeting with his waistband and looking down. Officer Anderson said he got out of the car, asked him if he was armed, and I said yes. Asked him if he had a CPL, said no. Per lien, he had no CPL. Watching the defendant's behavior, once he came in contact with him, all he did was illuminate him. And then he watched his behavior. And based on his behavior, that he acted on that, and that gives us a reasonable suspicion to do what he did. The court finds that the felony enumerating the complaint warrant did in fact occur in the city of Detroit. Probable cause exists to charge this defendant. Will be bound over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be June 20th, 2023, at 9:00 a.m. Thank you.
Ma'am. Counsel, what's your first name?
Alexandra.
I got you. Okay.
Ready?
Yes.
Calling case number 2356960, the people of the state of Michigan versus Cindy Anderson. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearm. This matter is scheduled for exam.
Good morning, Your Honor. Adam Booth appearing on behalf of the people, P 86266.
Good morning, Your Honor. Alexander Cho with the Neighborhood Defender Service of Detroit, P 85948, appearing on behalf of Ms. Anderson, who is currently present in the courtroom.
Cindy Anderson.
Thank you.
Yes, Judge, today's the date and time set for examination. Actually, we're about 10 minutes past the examination time. Ms. Jania Anderson was subpoenaed and has failed to appear, so the people are unable to proceed.
Your Honor, at this time, we would request that this case be dismissed without prejudice.
Witness is Jania Richard or Anderson?
My apologies, Richard, Your Honor.
Okay.
My apologies.
All right, so the matter dismissed without prejudice.
Your Honor, if we could also have an order to remove Ms. Anderson's
Have to
tether.
file a remove her tether?
Remove her
No,
tether.
what you do is take
Just show the,
the dismissal and a register action, and they'll take it off.
perfect. Thank you so much, Your Honor.
You're welcome.
Okay, good.
Come again?
I shouldn't have.
Right.
Yeah, let me hear all we have. Yeah. Have a good day, Ryan.
You too, now, take care.
Oh,
He's not here yet. Third,
oh,
he's not here yet, but, they said it was.
Hillary. Oh, good grief. Ugh.
Making up for BCC stuff.
I know, I seen that.
About 10 of them.
Yeah, 10. Yeah. Police officer.
This is kind of just kind of- she wants to ask.
Good morning, Your Honor. Mr. Leonard, who's set for 9:30, I believe, has let me know that he is about 10 minutes out. If you get an additional 10 minutes. Before calling that case. Thank you.
Counsel, what's your first name?
Veronica.
Okay, got it. Yes.
Courtroom 233, Judge Giles, courtroom number. Good, how are you? Honestly, I got it right here in my draft. I couldn't find your email. Yep, it's to me right now. Hold on, you said ACC one? Oh, TT. All right. At gmail.com.
Medication.
All right. You're welcome. I just sent it.
All right.
Mhm. Oh, it's 965-2283. Yeah. Oh, you're welcome. All right.
Sometimes. I know, I have. That's why I asked. Oh, stomach. Yeah. Okay. Right, is big.
None? Oh, cool.
Huh? Well, actually, she did tell me she didn't. So it was not. Why is yours? Which step?
That's, 0.
Parties ready on Earl Leonard?
Yes.
Yes.
Calling case number 2356761, the people of the state of Michigan versus Earl Leonard. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for exam.
Morning, Your Honor. On behalf of the people, Philip Henderson, P86029.
Good morning, Your Honor. Veronica Walrod with NPS Detroit, P85665 on behalf of Mr. Earl Leonard, who is behind me in the courtroom. Mr. Leonard, if you could state your name for the record.
Earl Leonard. Thank you.
All right, you ready to proceed?
Yes, Your Honor.
Yes.
The state calls Officer Corey Pierce to the stand.
Can you repeat the name?
It's Corey Pierce.
With the light,
CR.
So what this one? Raise your hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, pull the door towards you and seat, please.
Morning, officer. Could you introduce yourselves to the court, please?
Yep, I'm Officer Corey Pierce,
And where are you employed?
Detroit Police Department, 2nd Precinct.
How long have you been employed there?
It is 11 months now.
Okay. Were you working on May 5th, 2023?
Yes,
And what were you wearing?
full uniform, so, Class B, duty belt.
And were you walking or driving?
I was in the passenger seat, so we were
Okay.
driving.
Okay. And could you describe the vehicle?
It was a 2017 Charger, if I remember correctly the year. Fully marked, Detroit Police on the side, lights on top.
Okay. And did something happen on that day that brought you to court here today?
Yes,
Could you tell us how that began?
we were patrolling the area of Ardmore, and we were driving down the street. We seen 2 people walking on the sidewalk. They looked to be in a verbal argument.
Okay. And you mentioned Ardmore. Ardmore and what?
Florence.
Okay. And is that in the city of Detroit, County of Wayne?
Yes,
You said you saw 2 people argue.
yes, male and female.
Pardon?
Yes, male and female.
Do you see anybody from that argument in the courtroom here today?
Yes.
And could you point them out and identify them by article?
With a gray and like black speckled shirt. Male right there, black male.
Okay. A male, okay, I just want to clarify, okay. Now, if the record could reflect, he's identified the defendant in this case.
Record store is clear.
Okay, what happened when you encountered him?
We got out the car to investigate. Me and my partner observed like an L-shaped object in his pocket. And while we're talking with
Well,
him,
you can't say what someone else observed. You only say what you observed.
I observed the object in his pocket. I looked at my partner. We did our confirmation, like heading out that we do. And my partner began to investigate more while I started to talk to the female. And then he said the word that normally confirms that we found an object of.
Okay, what did you see?
In the L-shaped object in his pocket.
Okay, and did you recover that?
No, I did not physically recover it, no.
So did your partner recover that?
Yes, my partner recovered it.
Okay, did you see what he recovered?
Yes.
What was it?
A firearm. It was a Glock 43X.
What color was it?
Black.
Were you able to determine if the defendant had a CPO?
Yes, via link. Law enforcement network that we run. We checked the serial number, checked his name, and he did not have a valid CPO, nor he received one.
Did you ask him if he had a CPO?
Yes.
And what was his response?
At first, he was very, very hesitant, and then he said yes, and then we detained him just for further investigation, and it was determined that he did not have one.
Nothing further at this time, Your Honor.
So there was no call that brought you to pay attention to this verbal argument?
No.
Okay, and there was no one else around that asked you to intervene in it or interact with those people?
No.
Okay, and it sounded like you started to talk to the other party pretty immediately upon your arrival?
Yes.
Okay, so all that you observed was a bulge in Mr. Leonard's pocket?
Yes.
Okay, did you observe the process of your partner interacting with Mr. Leonard?
I do not recall.
You don't recall?
Not exactly.
Okay. So your partner asked him if he had a CPL, correct?
Yes.
Okay. And then he placed handcuffs on Mr. Leonard?
Not at first.
Not at first?
No.
Did he place handcuffs on him after he got an answer to that question?
We detained him for further investigation. Yes.
Okay. At which point he retrieved a weapon from his pocket.
Correct.
Okay. There was no indication in your interaction with the two people, in your interaction with the woman, she didn't say that Mr. Leonard had a weapon on him?
No.
Okay, and she didn't say that she was afraid of any use of a weapon?
She was saying
No, this is hearsay. I can't take what it is anyway.
Okay. Okay. You had no reason to believe that she was in fear a weapon would be used against her?
Not at the exact moment.
Okay. And she didn't give you any reason to believe there was a weapon?
No.
Okay. And you and your partner, when you were on patrol, you were on patrol in a vehicle?
Yes.
So you were observing this from the distance of being in a vehicle and observing people inside?
Yes.
Across the street, essentially, or halfway across the street?
Yes.
Okay. And so whatever you observed in a pocket would be from that distance?
We got out and then we approached him. That's when we observed.
Okay. And you didn't observe the butt of a weapon or any other part of a weapon that was actually visible to you? I
observed the L-shaped object in his pocket. I didn't see a physical firearm.
Okay. No further questions for this witness at this time.
I have one follow-up question here. You said on cross that that he was placed in handcuffs. Why?
To further investigate based off of his answer saying that he had a valid CPL and he had some tendencies that he was showing that he might have had something that he shouldn't have.
What do you mean by that?
The way he was talking when we asked him did he have a valid CPL, he stuttered, he was kind of hesitant to answer the question for us.
Okay, how long did it take before, you said that you said yes. Okay, so how long did it take before you started questioning, or when you started questioning him to when he said yes?
I do not know exactly the amount of time it took, but it was a slight delay.
Okay, thank you.
Sure.
That delay would have been a matter of seconds?
You can say yes.
Okay.
Nothing further from this witness, Your Honor.
All right, thank you. Step down.
And the state has no further witnesses. Your Honor, the state would motion for a bind over on count one. The officers were patrolling, they saw an argument. They got out to investigate that argument and saw an L-shaped, Officer Pierce saw an L-shaped object that he believed to be a firearm. Both officers did further investigation. During Officer Pierce's interactions with the defendant, he did state that when he was asked if he had a firearm, he hesitated. I would argue that's a sign of deception. He then stated yes. They placed him in handcuffs. They retrieved the firearm and determined that he was not a valid CPL holder. So we believe the elements are met, Your Honor.
Your Honor, defense would object to bind over. First, the officers approached Mr. Leonard and the person he was having a conversation with without any suspicion that he was engaged in any kind of crime. Certainly a verbal argument might be intriguing when they're on patrol, but it's not an indication of criminal activity. From there, they began to interact with him. They asked if he had a CPL, not a firearm, to which they said that he hesitated. But he had just been walked up to on the street by two fully uniformed officers while in the middle of a verbal argument. And so a couple of moments of hesitation, to me, does not indicate that there's anything additionally suspicious to their claim that they saw a bulge in his pocket. As this court is aware, a bulge in a person's pocket is not considered sufficient reasonable suspicion to initiate a stop, and an indication that he did or did not have a CPL on its own is again not an indication of criminal activity if there is no reason to believe that that person is engaged in carrying a weapon. I don't believe that this is a good stop, and the surge resulting from it, retrieving the weapon, would be the result of that bad stop. There was no reasonable suspicion here, so I'd ask the court to dismiss the case.
Your Honor, he did testify that he saw a bulge, but he specifically identifies an L-shaped bulge, which I would argue is consistent with being a firearm. So it was a reasonable stop for they had reasonable suspicion to investigate further.
Court having heard his testimony, arguments found as follows: the verdict from Police Officer Corey Pierce, who was in a full uniform, Class B, in the scout car. He was in the area of Ardmore, Florence. He saw two people walking down the street on the sidewalk, arguing. They stopped to investigate, see what was going on. I mean, there's absolutely nothing wrong with a police officer stopping and approaching anybody on the street. They have the same right just as you do and I do. You know, I can stop somebody, you know, that person that I try to talk to can decide whether or not they want to talk to me or not, and they can keep walking. You know, so that's not a stop. That's more of an encounter.
I'd argue that the stop.
No, you don't argue anything at this point. I gave you your argument. I am making my ruling. Okay, thank you. So at that point, it's not a stop. In this court's eye, it is definitely not a stop. Now, once they get close enough to him, Officer Pierce says he sees what is an L-shaped object in the defendant's pocket. At which point now it's an investigation. Now, the L-shaped object is, because of the contact here, is enough to allow for a Terry pat down and search, which is what happened? They took the weapon, now whether they patted them down first or they reached in, I'm not sure, that's a question of fact, it's gonna be left up to the ultimate trial fact. But definitely in seeing that, they have the right, and having that contact, that close proximity, have the right to do the Terry, pat down. You know, now, I don't know if they did the Terry pat down or not, but if they had, then they would have definitely found a weapon. Would have had the right to ask him if he had a CPL, which they did. He said, yes. He did have a CPL. They said they didn't put the handcuffs on him immediately. They looked and leaned, he had no CPL, he got arrested. So at this point, court finds that the felony enumerated in the complaint warrant did in fact occur in the city from probable cause existing charges defendant. He'll be bound over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be the 20th, June 20th at 9:05.
Yeah. You want to? I know Marcia said she. Mm. Minutes. Oh.
Been doing.
How's everything going?
Everything good. Can't complain. Hmm? Yeah, went to judge. Yeah, bro. Everybody else take no.
Morning, counselor.
Good morning. How are you?
Good. Can I help you?
Yeah, I talked with Philip on Friday, and we had an issue with Tevin Collier's date on Wednesday, and he suggested we zoom in if Judge was on the bench to try to pick a new date. He said the OIC is ill with COVID.
What was the client's name?
Tevin Collier. It's up on Wednesday morning.
I think he's working over to get 5 minutes at the most, and he's coming. He's gonna come in and swing, see if it's fine, get right back to the facts. Yes, ma'am.
We ready?
Yes.
It's not on the dock, it's from Wednesday. It's for scheduled Wednesday. Calling case number 2356984, the people of the state of Michigan versus Tevin Collier. Defendant is charged with count 1, impersonating a peace officer to commit a crime. Count 2, count 3, count 4, check not sufficient funds, $500 or more. This matter is here on adjournment hearing.
For the people, Philip Henderson, P86029.
And for Tevin Collier, Brent Leader, P70866. And I will waive defendant's presence for this hearing.
We'll waive his appearance for the purpose of this hearing.
Your Honor, the people would request an adjournment in this matter from the exam date of June 7th. I received contact from OIC Terrence Warner, who informed me that he does have COVID. After reviewing the file, I made the determination that he would be necessary to to make the case, to substantiate the charges. I notified defense counsel as soon as I knew that, and we wanted to address it before the day of so that we could get a successful outcome in the matter. And also, Your Honor, I would add that OIC Warner has indicated that he should be available June the 14th, if we could just adjourn it for 1 week so that he can get back in the office.
June 14th is not a good date for me, but the 15th is fine if the court is okay with it.
That's amenable to the status report.
June 15th at 9:30.
Thank you. And then, and Judge, I did submit I believe we sent in a discovery order, but I still do not have discovery from the people. I know I spoke with the prosecutor about this on Friday. So I'm not concerned about him getting that over to me. I just wanted to let the record reflect that we still do not have discovery at this point.
Where did you send it to?
Sent the order on, I believe June 2nd. Or
Where
June
did you
1st.
send it?
Who did you? I believe we emailed it, but I got to check with Mr.
Okay,
Rosemary.
so if you mailed it in, the chances of me getting it are slim to none, especially within the next week. You need to send it in to my clerk, and then that way I'll have it and sign it.
Okay, will do, Judge.
You have her email?
I will take that right now if it's okay.
I'm putting it in chat now.
Oh, thank you.
You see it?
I do. Thank you very much. June 15th, 9:30 in person.
Yes, sir.
All right. Appreciate it, Judge.
I need a adjournment form.
Yes, sir.
This adjournment is on the people.
And the prosecutor has the authority to sign that.
Mr. Glenn. Mr. Glenn. What's your first name?
William.
Thank you.
Parties ready on Reginald Coleman? Calling case number 2356965, the people of the state of Michigan versus Reginald Coleman. Defendant is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, felony, firearm. Count 3, weapons, ammunition, possession by a felon. Count 4, weapons, felony, firearm, habitual offender for notice. This matter is here for examination.
Good morning, Your Honor. Ed and Book appearing on behalf of the people, P 86266.
Wade William, P 36794, on behalf of Mr. Cole, Sir Station, Reginald Coleman. This is the waiver, Your Honor.
And the people have no objection to the waiver, Your Honor.
Thank you. Coleman, you understand that you have a statutory right to preliminary exam where the state must show by probable cause a crime was committed, and probable cause you had something to do with committing that crime. You understand that, sir?
Yes, sir.
Anybody promise you anything or threaten you in any way that you should waive your right to preliminary exam? Do so freely and voluntarily after having the opportunity to talk to your attorney about it.
Yes.
Sign the waiver of examination form. All right, court of finds you freely and voluntarily waive your right to preliminary exam. That is filed over Wayne County Circuit Court Criminal Division for arraignment on the information, which will be June 20th at 9 o'clock.
Thank you, Your Honor.
Thank you.
What's your first name? Counsel. Counsel. What's your first name?
Jackie.
Okay, got it. I.E. or wife?
I think you did, I'm just wondering if this. It's the second half, so you see arrest, so, yeah. No. Well, it's checking a discovery issues right now.
Oh, thank you.
Yeah.
Yeah. Thank you. Thank you.
Thank you.
All right, we just moving right along here. Yeah, everything on time.
I'm getting rid of PCC. Come on out there, man.
What I was gonna ask.
This your case?
No, this is Phillips. You gotta get him. I can go.
So you're ready.
Ready? Calling case number 2356875, the people of the state of Michigan versus Russell McGillery. Defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. Count 2, failure to stop at a scene of a personal injury accident. Habitual offender, second notice. This matter is scheduled for exam.
Your Honor, Philip Henderson on behalf of the people, P86029.
And good morning, Judge. Neighborhood Defender Service by Jackie Pilkowitz, P81653 on behalf of Russell McGillery, who stands to my right. Russell, state your name to the judge, please.
How are you doing, Your Honor? My name is Russell McGillery.
Morning. Thank
Good
you.
morning.
Good. All right, you ready to proceed?
Your Honor, there's just one preliminary matter. Of course, we were here last week concerning some outstanding discovery. I am in receipt of several additional body camera videos. However, I am missing the arresting officer's body cam from the arrest itself, which of course would be really valuable impeachment evidence. I've spoken with the people just now about this. They've indicated it doesn't exist, and that there was perhaps some sort of a malfunction with regard to the second half of this officer's video. I anticipate this is the officer who will be testifying today.
Officer Dobis is here, Your Honor, and as an officer of the court, he stated to me that the camera malfunctioned during the portion of the arrest, and it wasn't important.
I'll ask for a dismissal, Judge. I don't know if the court's inclined to grant that in light of the fact that I have other footage, but it is the arresting officer. It would be valuable impeachment evidence considered Brady at trial. And if it doesn't exist, it's not that as though I'm gonna get it going forward. So I would ask for a dismissal, Judge.
I understand, but, this is still, that might be more of an issue for a trial motion. This is a probable cause hearing.
Understood, Your Honor. We're ready to proceed.
All right.
Your Honor, I would ask the court for just a moment to confer with OIC Wagner on the officers that showed up. I was called into court while I was checking that, and I have just a moment to confer with him. Your Honor, after conferring with OIC Wagner, I don't believe the state has the necessary witnesses to proceed at this time.
Your Honor, I move for a dismissal without prejudice.
That's dismissed without prejudice.
Thank you.
Sure.
I'm always waiting for the egg to dry. You know, I'm
Yeah.
Take care, everyone.
All right.
Didn't see my name on the board. I went to the information desk. They sent me over to Frank Murphy. I went over there, didn't see my name on the board. I got a case in front of Judge Hackett. I went up to Judge Hackett's courtroom. I told the clerk, I said, hey, this is what's up. She said, you don't have a court date. She said, if you had a warrant out, I wouldn't let you walk out my courtroom. They turn around again and arrest me. I think it's the 22nd. Kept me for 3 more days. Let me go.
May
Still nothing.
22nd?
From the 22nd until like the 24th or 5th at mile. Just let me go, kept me to 72 hours, almost to 72 hours, and then just let me go. That was last week. They picked me up on this warrant on the 5th of last month. I'm like, well, I know I'm going to get a rain on the 6th. No, I know I'm going to get a rain on the 7th. No, I
Okay,
know
hold
I'm
on,
going to get a rain
hold on. It should be a video. Video goes on. Can you call, Joyce, Carmen? See how we would get a video, rain video on May 23rd. It was in front of, Jeff Capert. That's 10:30 a.m. People wish to be heard.
Your Honor, my records indicate our internal system that he was arraigned on May 23rd at 10:30 a.m. But I don't have proof of that other than the records we have in our system, so.
I didn't show when he was arrested, how many times?
Your Honor, may I confer with my witness?
Sure.
No, we have that he was arrested.
The judge. May 23rd.
Okay.
I'm trying to say it here. Right.
I mean, it does say it's scheduled for temporary. And that's fine. All right, thank you, Mr. Judge. All right, bye-bye. So she's gonna, Ms. Triplett is gonna start to, view it and listen, but she, can't give you a time frame because she has to listen to the whole arraignments on that day. It was scheduled for 10:30.
You think so? I'll just rearrange them out. It's gonna take her a while to do this stuff.
Yeah, she said that, you know, if they had a lot of arraignments that day, that morning, or if they had a little, but she don't know until she started. She just gotta listen from the start to, yeah.
Right. It's case number 235646. People of the state of Michigan versus Sean Holloway, AKA Paul Martin Holloway, AKA Terry Martin Gordon, AKA Terry Gordon, AKA Martin Green, AKA Sean Martin Holloway, AKA Martin Green, AKA Terry Gordy, AKA Henry Green, AKA Henry Holloway. Fairness.
For the people, we are, Philip Henderson, P 86029.
Okay, please, this honorable court, very spoke on behalf of Mr. Paul Holloway, who stands to my, right, and directly behind me, Mr. Holloway, state your name, direct. Paul Martin Holloway.
All right, thank you. We're gonna be in arraignment, wait for a reading stand, you know, you want me to go through all the charges.
Judge, I'd ask that you, read the charges against Mr. Holloway.
Holloway is charged in count 1, breaking and entering a building with intent. Did break in a building located at 8820 Mansfield Street, intent to commit larceny therein. It's a felony for 10 years. Count 2, larceny from a building, did commit a larceny in an apartment building by stealing a furnace and hot water tank, contrary contrary to NCL 750.360, a felony 4 years or $5,000. He also has a habitual offender fourth offense notice.
At this time, Judge, as it relates to the reading of the charges, my client stands mute.
All right, then not guilty be in on his behalf. There is a bond in place, personal reconnaissance bond, $22,000. Kind of a weird number, but also the conditions may not use alcohol or any illegal substance, may not possess or purchase a firearm or other dangerous weapon, cannot enter 8820 Mansfield Street or those premises or be anywhere near it. Any other issues as to bond?
No, Judge.
No, Your Honor.
Then, well, we've already held a probable cause hearing, but we should proceed to probable cause. Are there any issues in regards to discovery or anything like that?
The only thing was, Judge, and I did get a chance to see a 6-second video that they believe they sent, but I don't recall getting the discovery I had, only had the paperwork in it.
Your Honor, we have an export log from evidence.com that shows that was sent on May the 25th to Mr. Polk, and that's the best evidence that I can offer to the court.
The only video was a 6-second video?
Yes.
Yes, Your Honor.
All right, we'll proceed to the next step. All right, prepare to go forward with exam today, or?
Judge, I would ask for a group adjournment.
For what?
To be able to verify whether or not he was actually arraigned.
Doesn't matter, I just rearranged it. I took care of it. It's just taken care. We did, you know, there's no reason for me to put it over.
So, in speaking to my client, Judge, at this time, he's, I believe, electing to waive his preliminary exam. Is that correct, sir?
We have no objection, Your Honor.
All right.
Okay.
And just for the record, I did look at the discovery and the video was sent to me.
Okay.
I never saw it before.
All right, do people have any objection?
No, Your Honor.
All right, Mr. Holloway, you understand that you have a statutory right to preliminary exam where the state must show by probable cause a crime was committed and probable cause you had something to do with committing that crime. You understand that, sir?
Yeah.
Anybody promise you anything or threaten you in any way, get you to waive your right to preliminary exam?
No.
You waive your right freely and voluntarily after having an opportunity to talk to your attorney about it.
Yeah.
Can you sign the waiver of examination form?
Yeah.
All right, qualifying that you freely and voluntarily waive your right to preliminary exam as bound over the Wayne County Court Criminal Division for arraignment on the information. It should be June 20th, 2023.
June
9
20th.
o'clock a.m.
So you go outside.
All right, thank you, Mr. Pope. Take care now.
I shall.
Got to, brother.
Okay, come on.
You ready? Calling case number 2356673, the people of the state of Michigan versus Kayla Finney Cairo. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for exam.
Good morning, Your Honor. Adam Buka appearing on behalf of the people, P86266.
Good morning, Your Honor. May it please the court, Dwayne Johnson, P41842, on behalf of Ms. Plaintiff Carroll, who is standing to the United States Nation.
Kayla Finney Cairo.
All right, you ready to see?
Sort of, Your Honor. My officer, Sergeant, or excuse me, Corporal Joseph McCon checked in with the court. He's testifying in Judge DeBree's courtroom. Now, I don't want to waste Mr. Johnson or the defendant's time in this case, so I fully understand whatever the court would like to do, but if possible, I guess I would ask for some more time for him, if the defendant would like to hold the exam.
Yeah, I would respond that, scheduled for this time, we're ready, and we're here, ready to proceed, so we'd ask the matter to be dismissed, and it can be rewritten if necessary.
Well, I mean, he's here, he's in the building, he checked in, so I'll give him some time and see if he comes out.
With that, decision, Your Honor, my client at this time will probably waive the exam.
Yeah. Anyway, no. Well, thank you. All right.
All right, Ms. Queen Carroll, You understand that you have a statutory right to preliminary exam where the state must show by probable cause a crime was committed, and by probable cause you had something to do with committing that crime. You understand that?
Yes.
Anybody promise you anything or threaten you in any way to get you to waive your right to preliminary exam?
No.
You waive your right freely and voluntarily after having opportunity to talk to your attorney.
Yes.
Can you sign the waiver of examination form?
Yes.
People have any objection?
No objection, thank you, Your Honor.
All right, the court will find that you freely and voluntarily waive your right to preliminary exam and is bound over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be June 20th at 9:00 p.m.
Thank you, Your Honor.
Thank you.
Everybody have a good day.
One second. Yeah. Yeah.
I'm sorry.
What
Your
about you,
Honor.
Mr. Johnson?
Oh,
Yeah, that's you.
All right, that's it. Rappiano.